Good afternoon. I'm Inigo Jimenez, I'm legal officer in Unit R5 here in DigiConnect, and now I'll make a brief presentation on some IPR-related issues that we expect that you are handling during the implementation of the project. Well, the first thing, if you already have taken part, for instance, in other projects under the framework program research, you may have noticed that the provisions on IPR in the grant agreement for CIP projects is quite different from the provisions on IPR in FP7 projects, for instance. It doesn't mean that for CIP IPRs are less important. It's just there's a lack of legal basis to impose further provisions in the grant agreement. But however, we at the Commission, but basically use the people carrying out the projects. You have to realize that CIP projects rely on the fact that IPR is already generated. You are not doing research and technological development. You start from something which you already hold. So we expect you to take into consideration, I guess you have already done, the importance of handling from the very first moment, but mostly during the implementation of the project, how to take care of what you brought to the project at the very early stage, and how you protect and you use your achievements during the lifetime of the project under CIP. So the first issue that you may have noticed that there are very few definitions on IPR par rapport à the FP7 Grant Agreement. CIP just speaks about foreground and access rights. We don't speak about background. Say that we don't have rules for participation that we have in FP7 for CIP, so we don't have legal basis to go further. But as you said, it doesn't mean that background is not important in CIP. It's just the contrary. It relies on the fact that you have already done research and technological innovation. You have protected this know-how, and you bring to the project when you start the work with this know-how already protected, and knowing what you want to do with it and how you are going to use it and exploit it and disseminate it. From the definitions, I would just stop for a moment in the definition of foreground. It's to be noticed that foreground is not just the final device that you may fabricate or the final services you may provide. It's everything you generate during the lifetime of the project. So any knowledge you generate, as soon as it's generated, is foreground. And the obligations in the grant agreement related to foreground applies also to this kind of information, knowledge, know-how whatsoever, not just the final devices or the final services or products that you expect from the project. This is quite important. We understand that you already are aware, because if you don't protect adequately the foreground, as soon as a foreground understood as any kind of information or how, as soon as you generated it, it may jeopardize the performance, the future performance of the project. The first provisions regarding IPR under the CIP model agreement is related to the ownership. It's very basic. Ownership of foreground resides with the beneficiary carrying out the work generating the foreground. There are some provisions on joint ownership, but relates to a future agreement made at the consortium level. We don't have legal basis to impose a by default regime as we do in FP7. So if you don't have foreseen how to exploit, how to use a foreground which is jointly generated, you may jeopardize future developments of the project. So we expect you have already handled this kind of issues where the grant agreement has not foreseen a default regime. It's also important, and it's explicitly stated in the grant agreement, the fact of the rights that your employees may have under the foreground are assigned to the beneficiary, to the legal entity, because in fact the obligations, the rights and obligations are imposed on the beneficiaries, on the legal entities, which is not always the case under national laws, which may award some intellectual property rights on the employees, not the legal beneficiary. So we also expect that you have already foreseen this kind of agreements with employees to assign the results of their work in order to allow the beneficiary, understood as the legal entity, to go on, notwithstanding which is the employee, which is behind the work. The second obligation or provision related to APR foreseen in the grant agreement is the obligation to protect. As I said, well, there's an obligation if the foreground is capable of industrial or commercial application. In the sense that, let's say, for instance, industrial application, as I said, well, foreground is everything you generate during the lifetime of the project as a consequence of the work carried out during the lifetime of the project, not the product of the device or the service itself, but the obligation on protect foreground also applies to this kind of knowledge, general knowledge or information. Protection does not mean that you avoid someone else to use it. We understand protection in the sense that nobody else may claim the ownership rights on the foreground which is generated with the taxpayers' money. Protection does not mean to patent. In your case, software is usually not patentable. There are many kinds of protection tools, and we expect you to choose the most adequate to handle how to protect in the most suitable way any output of the work, taking into consideration also the legitimate interest of the other beneficiaries. As I said, well, contrary to FP7, there is no provisions on transfer to the Commission if you don't protect, but however, we expect you to protect to allow the development of the project and to take full benefit of the results. As I said, protection, the way for the protection of the protection tool may take different forms depending on what's to be protected according to national laws. As I said, it doesn't mean that you avoid anyone else to use it. The protection involves the fact that nobody could claim ownership rights. So at this stage, I think it could be interesting, yeah, the fact that so in Work Program 2012, it's foreseen that software should be distributed under a recognized license by open source initiative or this kind of initiatives. This is also a way of protection. As soon as you put a foreground in public domain, it's recognized as your output, so no one else could claim ownership rights because it's already in public domain. So a way of disseminating results as soon as you obtain them is a way also to protect, because it becomes part of the state of the art. So it couldn't be, let's say, in case if patents are possible, it couldn't be patentable. You will be recognized as the only owner, and no one else could claim ownership rights. The third obligation related to APR, which is imposed in the grant agreement, is the obligation to use. This is an obligation de resulta. It's not that you will make your best efforts. No, you are obliged to use the way you expect but you are obliged to use because CIP, we are no longer in research and technological innovation development. We are in innovation. You are facing already industrial or commercial. You are foreseeing already industrial or commercial applications of the results, and that's the main objective of projects under CIP, to bring to the market innovative solutions. So that's why we have a formal obligation to use in the way you may decide, but to bring to the market this innovation. The fourth obligation in the grant agreement is the one related to dissemination. As I said, well, it also serves to the general purpose of projects under CIP, which to to bring to the market innovation, so a way to bring to the market to raise awareness is by disseminating. Dissemination is always also, or maybe also a way to protect, as I said, as soon as you put something in public domain, nobody else could claim ownership rights, and you will be recognized as the owners of this output. There are some kinds of, some sorts of obligations regarding dissemination. You should ensure that foreground is disseminated. If you realize it's no longer an obligation de resulta, shall ensure it's not like in use, shall use, because here you should also take into consideration the legitimate interest of the other partners, not to jeopardize the whole project itself. So that's why there is a prior notice of any dissemination activities of at least 45 days to other beneficiaries in order then to object if it attends against legitimate interest, or let's say the interest of the project itself to go on. So at this stage, let's say that for the purpose of the project, you may keep some foreground secret as long as there's a real purpose for doing so. And well, Article 18 of Annex 2, the obligation to mention the EU financial support in any communication or publication. It should be also noticed that for some purposes, use and dissemination, the Commission is also entitled to use and to disseminate the results you obtain. If you don't disseminate it properly, the Commission may consider that within the purpose of the CIP program to bring innovation to market, so the Commission could disseminate the results. But what I would like to raise your attention is the fact that the Commission is entitled to make available to Member States and associated countries information related to your foreground if it's relevant to public policy. It doesn't mean that you're transferring ownership, you keep ownership, but for public policy purposes, the Member States and associated countries may be entitled to use it for their own purposes as long as they are not commercial and non-competitive use. And also the Commission is authorized to publish publishable reports and deliverables. So that's why when submitting the report, you have to provide a summary, a report which to be published, removing then what you consider confidential information, classified information, whatsoever. If you don't qualify the report as confidential, or then you are awarding the Commission full rights to publish it and to disseminate it the way to consider to achieve the objectives of the project. And the sixth main issue related to APR in grant agreement for CIP projects is the access rights to foreground. As I said, there are no provisions on access rights to background, as for instance in FP7, but we rely on the fact that you have already foreseen that at consortium level, because otherwise perhaps there's no way to start the work. You should have foreseen how to bring into the project at the very first moment the knowledge you already have, at least for the first day. So we don't enter that because, as I said, we don't have legal basis to include it in the grant agreement, but we have provisions on access rights to foreground. Basically, yeah, foreground is granted royalty-free basis unless agreed to otherwise. Here again, we don't have it's up to you to decide. If you don't decide at consortium level, this would apply. So, but we understand that you have already foreseen all these kind of things for your own benefit and the benefit of the whole project itself. The access rights to foregrounds to be granted royalty-free if foreground is needed to enable the requesting beneficiary to carry out its own work, sort of compensate or to complement the operational capacity of each beneficiary, and if foreground is needed to use the requesting beneficiaries or foreground, as long as there was or there is a formal obligation to use. If a beneficiary couldn't use its own results because it needs licenses from other beneficiaries, then this beneficiary holding the licenses should award them royalty-free to other beneficiaries in order to allow them to exploit fully the results of its work. Yeah. Besides this, there are some special conditions in the grant agreement, which I guess have been inserted on, when applicable in your cases. A special condition on publication and free accessibility of results is to be inserted in the grant agreement in case of pilot A through the special condition A in Article 8. And according to the requirements in the work program, also there are some special conditions may have been inserted in your grant agreements related the necessity to award access rights to foreground for cross-border interoperability purposes. It does not contravene the ownership regime or the confidentiality obligations, but however we consider that this kind of extra obligations to award access rights to foreground are for the sake of the program itself, and is necessary to comply with the objectives established in the work program. And finally, well, just pay attention that the obligations on the special clause apply after termination of the grant agreement. So the obligations to award access rights does not end with the grant agreement. It survives later on just for the purpose of promoting that truly there's a cross-border interoperability, and this special clause, even though the grant agreement is already over, allows the full objective of this clause.